Police Nochulwana from the Development Bank of Southern Africa. I've raised this question with the Prof some time ago. Sovereignty. Is it correct to characterize sovereignty in Africa as this unchanging, atomistic, and static thing that we, as you put it, we are sort of trapped into it? I'll tell you why I'm asking the question, Prof. I'm not a lawyer. I studied political science and economics and international relations. There's a huge literature in international relations that is actually pointing to this notion of sovereignty being a changing phenomena, which is in different parts of the world innovatively sort of shaped differently depending on what you are dealing with. In East Africa, for instance, there is a bill that is in front of the East African community countries around one-stop border posts, which is one form at which countries sit around and arrange to share some sovereignty around their territories. And it's been agreed by 4 countries, and there's one country that has to accede to it, and there are whole issues that are raised here that are about sharing sovereignty. To show indeed in terms of the real example that I've just given, there was a process recently in our country, not too far from here, where a bilateral agreement on the Libombo-Garcia one-stop border post that we have between this country and Mozambique was passed through both houses of parliament. Now the process is about to be operationalized by the 2 countries working alongside other role players within that to create a platform for sharing of such sovereignty. So I'm trying I think Paul was right earlier on, there are challenges in terms of the willingness to share sovereignty, but there are examples that are emerging that indeed Southern Africa and the rest of the continent, some of the RECs, are working around ways of, and another question that I wanted to ask is perhaps in the definition of regional integration in relation to sovereignty. You know, we tend to, we tend to conflate sharing and pooling of sovereignty as if it's one thing. If you can clarify that, Prof.
I think I wanted to comment on the fact that, and the issue that my young brother Henry raised to say Zambia could take South Africa to WTO dispute settlement mechanism, body or whatever. I wanted to come in to say why member states do not take each other to court. And I want to talk from the premise that I'm handling non-tariff barriers in COMESA for some time now. And the COMESA Court of Justice has always existed, and its sole mandate is to, give arbitration to interpretation of the COMESA Treaty as per Article 5, as articulated by William. And notwithstanding that the COMESA Court of Justice always existed all along the trade liberalization, no member state has taken another to court. And in that, I wanted to say that the issues that were raised in the morning by Professor Mukandawire are very real and alive. There are so many issues behind member states dealing with one another. It's not all about the products that are coming from Egypt to Mauritius, for example. It may not, when you talk to a country and tell them, why don't you proceed to the COMESA Court of Justice and try to resolve this matter that has been in existence for a long time, they'll tell you, I can't take Zambia to court. Other than the milk product that we are exporting to Zambia, for example, we have a myriad other exports to that country. And if we do that, we'll jeopardize our market. There are many other considerations, political, social, that go into the considerations before a member country can say they now want to take the other one to court, leave alone to the World Court under the WTO. And you will find that even most of our dispute settlement mechanisms, we have a lot of leeway to say you start with the Secretariat, you go to the bilateral consultations. If they don't, you get another party, a neutral party. You know, there are all those niceties before you can now really say that you can proceed the Commercial Court of Justice as the final and last resort. And also to comment and say that private treaties, both public and private entities benefit from, are beneficiaries of the treaties. So it's not only to benefit private entities or parties. If the private companies are making money, the government is making money as well in terms of taxes, internal taxes and others. I wanted to understand from William, in terms of whether you want to call it domestication, giving it legal effect, transposition, to me is one and the same thing. But I wanted to ask, in terms of the case of Mauritius and Polito, a company in Mauritius that took its own government to court, the first point of the commercial treaty not having been given legal effect in Mauritius, just clarity I'm seeking is the fact that now that that same treaty was signed by the head of state of Mauritius, does that not constitute ratification by Mauritius? And just to simply say that if that be the case, then it will be, I'm not too sure that many members of COMESA or any other regional economic community for that matter have gone ahead to domesticate or give them legal effects once they have signed those treaties. Then we are standing at a very dangerous ground in terms of implementing a treaty that has not been, if that be a thing really. So I'm seeking this clarity. Thank you.
Just to say that I think there are a few steps in when a treaty is concluded for it to actually, between the time that it's concluded and then the time that it's actually effective within a country. So at the time that the treaty is concluded, heads of state will sign the treaty. So there's signing of the treaty. And then there's actually ratification. So they'll deposit instruments of ratification. But then that doesn't mean immediately that that treaty is part of the national law of the countries. I think normally that's what the general perception is. But then the point is that different countries have different legal systems. For some, on the one hand, as I highlighted, that some follow a monist approach, and that's mostly the Francophone countries from historical times. Most of the Francophone countries will have a monist approach, and so once they ratify the treaty, it automatically becomes part of the national law. And once it's part of the national law, national courts within that country can actually then give effect to whatever is contained in the treaty. Because national courts, on the one hand, the dilemma is that national courts can only actually base their decisions on national laws. And so the regional agreement actually has to become part of the national law for a national court to actually interpret. On the other hand, there's the dualist approach, where after ratification, you still have to have subsequent legislation incorporating that treaty into the national law of the country. And this is what was actually at issue in Mauritius, where for them, they actually have to go ahead and actually implement separate legislation to make sure that after ratifying the treaty, it then becomes part of the national law, so that even national courts in Mauritius can then interpret and give effect to whatever is contained or the obligations that member states have undertaken at the regional level. So it's basically that link of actually making it international law. What this case is showing is that because the provision was clearly and unconditionally provided the right, Mauritius had actually complied with what is in the COMESA Treaty by eliminating tariffs by the actual set date. It was very clear, it was by the year 2000, Mauritius had actually done this. But then the problem was when it actually then introduced new duties. And what the court was saying was that even though the treaty had not been domesticated in Mauritius, Polito-Pains could actually come to the COMESA court because through Article 26, it can come to the COMESA court to challenge infringements of the treaty. And this is actually what was happening in this particular case. I hope that maybe clarifies that question. Thanks.
Let me refer very briefly to this last issue about the status of international trade agreements within the law of the land. And William is quite right pointing out the difference between the monist and dualist positions. But the lady from COMESA is asking, the moment that the head of state signs an agreement, does it not apply within the land? No. In the life of an international agreement, there are stages. Representatives negotiate till they have a final text. Then there's a nice party with a lot of bubbly and they sign it. That is not a binding agreement. That is a signed agreement. That agreement will still enter into force, and that happens through its own requirements about entry into force. If we want to know how agreements enter into force, read the text. And the typical rule in our part of the world is normally 2/3 of the member states must ratify and deposit their instruments of ratification, and then a week or a month later the thing is entered into force, but only for those who have ratified. Now it's a binding treaty. What is its effect? It binds the parties who have ratified. They have now to respect it. Does it mean they must incorporate into the law of the land? No. You violate your treaty obligations on the interstate plane if you don't respect your treaty. Trade agreements is a little bit more complicated. Your tariffs, you promote, you implement domestically. A national official will refuse to issue a permit to allow the Zambian honey into the country. That is why dispute settlement then about the state not complying with its treaty obligations becomes vital. And it's no different. The answer to whether a treaty must be incorporated or not, you find in your own national constitution. But that is no defense for not having complied with your international obligation. And that is why William's point is important. The fact that that treaty, the COMESA instrument involved here, was not incorporated and made part of the law of the land of Mauritius was irrelevant for the question as to whether Mauritius had violated obligations or not. So let's not confuse these two things. Let's not confuse them. And he also pointed out that that part of the application by Politol to force Mauritius to incorporate the treaty, that failed. But it succeeded on the merits of its application. And what was that about? Respect the tariff obligations which you have entered into under COMESA. But there's one point, Madame, where your interpretation about, or your explanation about why African states don't litigate against each other really worries me. I still don't know what all the reasons are why they don't litigate against each other. I suspect that to a very large extent might have to do with what we heard this morning about the history and what happened in the 1960s and so on. My response to that would be the game has moved on. But when you say, no, we can't take them to court because we also export so many other things to them, then you are implying that their illegal reaction to your lawful invoking of a treaty obligation is the reason why you don't respect the law that protects you. If that is our understanding of the effect of our treaties, that we can't dare to implement them or to make them effective because the retaliation from the other side will lead to this downward spiral, then we are at the mercy of the mood of the Monday morning. No, it can't be true. If it's true, change it, please. Okay, then That cannot be a rules-based system. Okay, that's not what our system should be, in my book at least. Very quickly, Henry, if you allow me, about the other two. What will be the consequence of SADC states litigating against each other in Geneva? Very good news lines. That will really make the news. It will be far more expensive and time-consuming to travel all the way on Swiss Air to Geneva in order to litigate there, and to most likely to employ lawyers in Brussels, Washington, and Geneva to defend your case. If you look at case law coming out of the WTO dispute settlement system, ladies and gentlemen, the lawyers have captured that boat. They make money left, right, and center out of it, and the jurisprudence becomes extremely legalistic. I hope we will not go that way. But this is not a legal question whether they will go to Geneva or not. It's a practical issue. I don't see signs that the conditions are sufficiently ripe between us that we will do that. But I would really like to plea to give, as the Beatles had it in their song, to give peace a chance. Give peace a chance and go litigate against each other. But in principle, yes, you can litigate there. There's one technical implication. A court with jurisdiction over WTO legal instruments does not have jurisdiction to entertain cases on SADC legal instruments. So if you do go to the Geneva, you can't base your action on SADC legal instruments. That you can't do. And that's a report. Before you're too keen to pack your suitcases to go to Geneva, just make sure whether they will entertain your hearing. But the obvious answer is those instruments that we have created for ourselves and have staffed with our own lawyers to solve our own problems in our backyard, they are the suitable ones. Give them a chance. Give peace a chance. Okay, and then the gentleman who started off by reminding me that we've had this discussion again is actually saying to me that the fact that there is now reopening the debate means the first round was very unsatisfactory. I accept that. But maybe that's now the point about how sovereignty should change over time, and we have shared sovereignty. I fully agree with all of that. But that's not the question to be asked. The question is, why does it not happen? Sovereignty is not, don't overestimate sovereignty, ladies and gentlemen. It is because of all the political invocations, all the political claims being made in the name of sovereignty, that we tend to read into it much more than we should read. Sovereignty, technically speaking, ladies and gentlemen, for me, is about essentially 2 or 3 legal consequences. The first one is a treaty can never bind a state unless it has ratified it or acceded to it. No treaty can bind a state unless it has, out of its own volition, accepted to become a party to it. That's very old-fashioned and traditional, but that's an ultimate protection of sovereignty. The other one is that over your own territory you are boss. No one or nothing can enter the territory of another country unless the laws of the land so provide. And if I would travel to Windhoek, where I often do, and steal a chocolate bar from the local South African Pick and Pay shop, and the Namibian police would arrest me, I can't claim my South African nationality as a defense. I am under the laws of Namibia. Jürgen? Remember, while you're here, you're under the laws of South Africa. On the other hand, if I happen to escape and I go back home, the Namibian police can't take the next plane and come arrest me in my house in Stellenbosch. We all know that. That is sovereignty. When sovereignty enters into the murky waters of some of the debates that we are discussing now, then we enter unpredictability. But you're absolutely right, sir. Your examples about one-stop border posts What are they? They're where two sovereign states enjoying sovereignty and jurisdiction over their own territory come together at one joint point in order to facilitate trade. That was quick. To facilitate trade, they are sharing their jurisdiction. But they couldn't do so before they've agreed to do so. Why do they agree? Not because they want to be nice to each other, because they want to benefit themselves. And why is that not happening? Now we're into part of the discussion of this morning, our keynote speaker. Why don't we do that? I don't know. I don't know. But these are the discussions that we then should have, not as legal issues, but about the legitimacy and preparedness of governments to move forward with the regional integration exercise. Is there an attractive set of conditions or a plan that will entice us to be more prepared to cooperate with each other? Now, Trudy Hudsenberg has promised that she'll give us the answer to that one tomorrow morning.
I'm Amos from the University of South Africa, UNISA. I just want to ask this question. It could be simple, but the role of individual member states in SADC, especially in the respect of the rule of law. Let's consider it, the issue of the Kembo case. If it was not happening in Zimbabwe, if it had happened in any other country that is not Zimbabwe, would it have gone this far? And this impact on the tribunal?
Akare Mwangenda from Brunel University, London. I wanted to ask a question on the issue of the community law and incorporation, the international law thing about the dualist and monist. Is there anything to be learned, since we are trying to mimic in the economic integration projects, trying to mimic the European Union? Is there anything to be learned from what the European Union did with regard to the UK in terms of incorporating EU law into the UK? Because what the UK did, and my understanding is was required to do, was to pass a special type legislation, one act, the European Communities Act, that effectively surrendered, if you would like, sovereignty in a lot of areas vis-a-vis the implementation of European law into the UK. So that, basically, I'm saying this because this solves quite a number of issues, so you do not have to talk about incorporation piecemeal. It sort of takes care of the future, if you would like, with regard to particular aspects of European law. I just wanted to know if that's an example we could follow.
With the Campbell case, now that's the case that was brought by Mr. Campbell, a citizen of Zimbabwe, to the SADC tribunal after his land was expropriated. Would that have resulted in a different outcome had it been heard in another country? Well, it depended on the country. If that sort of issue had been brought in a country, let's say in Namibia, where there is a supreme constitution with a Bill of Rights, the courts of the land would have entertained his claim. That was not, constitutionally speaking, possible in Zimbabwe because those protections have been abandoned, have been cancelled out over time. So the extent of your domestic protection, what is in your constitution, if your constitution protects you, it protects you, then it would not have gone to the tribunal. You're quite right. But what you are pointing out has another implication. If some important central players on the African continent are prepared through their domestic and constitutional dispensations to allow the rule of law over so-called policy issues, that is very important evidence of the advance that the rule of law has already made in many parts of the law. There's theoretically no difference in allowing that same logic to apply to your doing business with your neighbor, except for one thing, reciprocity and trust. And these are the functional things. The second question about the example of the United Kingdom joining the European Union, you're quite right, except for one qualification. It is true, English law on that is based on the common law, dualism. But the additional element in the case of EC law was the direct effect of EC directives. We haven't got that here in our part of the world. We do not allow our regional secretariats to exercise law-making supranational powers. But you're quite right that once-off piece of legislation, which is theoretically the incorporation of the powers retained in the EC instruments with respect to the Commission in Brussels, that is a one-way opening of the door for direct effect to take place. Fortunately, we haven't got that problem yet in our part of the world. But your suspicions are sound, as most suspicions are not, but in this case they are.
Let me add one comment to what Helen said. And I think the point that I was making, and which Director General Acevedo was making, was that taking disputes to a panel should not be seen as a hostile action. It should be just seen as one of a range of tools that are available, and which we as African countries should not be afraid of taking, and we should not fear retaliation against such acts. Maybe the time has not reached, but I would argue that the time has reached where we can consider and actually go ahead and make such acts. But thank you very much to our two speakers, Professor Erasmus and William Mwanza. I think they have shared very well on the very difficult topic.